Good afternoon and welcome to the Justice Center Summit session on the Surrogate Decision-Making Committee. We will be recording this seminar and it will be available on the Justice Center website within the next week, hopefully. So don't worry if you missed part of this, you'll have another opportunity to see it. Before we get started, let's just go over some Zoom housekeeping things to note. So this is a webinar and all participants are muted and off camera. So if you look at the control bar at the bottom of your screen, and if you don't see that right now, just hover move your mouse down near the bottom and it should appear. There's two important functions that we want to draw your attention to. The chat function will be posting information. There's already information posted in there right now throughout the webinar. And you can also use this feature to ask any questions that you have that you would like to ask the presenters. And we will take a break and ask those questions that are posted in the chat, so long as they're about the Surrogate Decision-Making Committee. Closed captioning is also available if you would like that option, and you can access that by clicking on that icon. And that is it. Just a reminder again, the session is being recorded, and at the conclusion of the Justice Center Summit next week, we'll be sending everyone an evaluation form. We really value your input and would like your ideas for additional topics in future years. So I will turn it over to Vicki Klingon now.
Hi. Good afternoon, everybody. Thanks for having us and for joining us today to hear more about the Surrogate Decision-Making Committee. I'm Vicki Klingon. I'm the director of the Surrogate Decision-Making Committee unit here at the Justice Center. And with me is Stephanie Arana. I'll let her introduce herself.
Hi, everybody. It's a pleasure to be here with you this afternoon. I'm excited to be here to talk about our program and our volunteer opportunity. I am the volunteer and contractor manager of the program, and I've actually been with SDMC for 6 years in June, which is really exciting. It's a wonderful program. My role is to oversee our wonderful volunteers in the program and to oversee our 6 regional contract offices who hold the major medical hearings across the state. I hope you enjoyed today's session, and I'll hand it over to Vicki to get us started again.
Thanks, Stephanie. I've been with the Justice Center since 2018, just about 5 years this year, and have been with the Surrogate Decision-Making Committee as director since 2020. So I've been doing this for a little while through our pandemic experiences. So we are going to talk to you today about Surrogate Decision-Making Committee and give you basically an overview of the program, as well as some information about becoming a volunteer. So SDMC is a volunteer-based program. We make decisions for people who can't make decisions for themselves. This training today will actually cover your introductory training should you choose to become a volunteer. No pressure, but we are always looking for volunteers and looking for great people like you who might be out there looking for an opportunity. So with that said, I'm going to kick us off with a poll. We'd just like to know a little bit more about who we have here with us today. So we are gonna have a poll pop up here, give us a little bit of information about who you are and whether or not you're interested in becoming a volunteer. I don't see the poll. There we go. So there's 2 questions there. If you don't see 2, you'll have to scroll a little bit, but we just quickly, I guess pick the one that most applies to you in your role. And then let us know if you're possibly interested in becoming an SDMC volunteer. You can be not sure yet, or it can be something you're not really looking at right now. The program will be useful whether or not you want to become a volunteer. We'll let you have a chance to start that poll. Give you another minute to answer those questions. I think that's probably good. We could probably see those results. Okay. Oh, looks like we have a lot of provider agency representatives with us today, as well as some other people. And some people are already interested in becoming a volunteer. Well, I hope that we answer any questions that you might have about that in this presentation. We can shut that poll result down and move right along. This is our agenda for the day. We're going to be going over the program overview and history, our application process, and then the 3 important questions that we are asking at SDMC committee hearings. And then we're going to take a short break. and come back and talk about the hearing process, deliberation, voting procedures, and our public officers law that governs our volunteers. So, get started a little bit with our program history and overview. The SDMC program was established by Article 80 of the Mental Hygiene Law in 1986 as a pilot program. It was one of the first in the nation to look at better ways of serving people with developmental disabilities or other inability to make their own decisions who needed a quick answer to medical needs and an easier way of accessing that answer for them. So by 2001, it was statewide, and we used to be housed at the Commission on Quality of Care, which then was rolled into the Justice Center in 2013. And SDMC is an alternative to the court system. We make decisions for non-emergency major medical and some end-of-life care. And SDMC works on behalf of qualifying individuals who lack capacity to make their own medical decisions and have no legally authorized decision maker who can do that. And the way that we do this is by utilizing trained volunteers who come together similar to a jury, like a small little group of people who, with experience with these populations, who can, listen to the information and make a decision. The benefits of SDMC are that it's free. First of all, there's no cost, there's no court costs, so you don't have to hire a lawyer or go through any complicated process. It's timely. We try to answer questions quickly and get to the results as fast as we can. Our schedule for turnaround is within 7 to 14 days, depending on whether a doctor has indicated this is an expedited case. We can also turn it around fairly quickly if we need to. If something is a really urgent need, we can do it sometimes within 1 day, but we do try to get them done as fast as possible. It's inclusive. SDMC always includes the person who needs the decision made. So it's that person whose medical needs are in question. They're always part of this process. They're at the hearing. We're making sure that they've been asked about what's going on and that they have an opportunity to share their thoughts and feelings on it. We also include any natural supports. So if there's a friend who helps that person make decisions or who is just involved in their life, they're included. Anyone that is important to that person can be included in this process. We also respect legal rights. There is a process of notifications that's required under the law, as well as people who have objection rights that can stop the proceeding. And we also protect the autonomy of the individual at the center of a decision. We want to make sure that they are able to make any decisions that they're capable of making. So SDMC is literally just a decision for one particular medical need. We're not guardianship. We're not making a decision for the rest of that person's life. We're just making a decision based on this one question of whether or not they should have a procedure done. Prior to SDMC, there were, delays in people's care because courts take time to make decisions, and it wasn't a quick process. Partly due to that, people who likely lacked capacity were probably signing for their own informed consent, even if they didn't fully understand. And the emergency exception in public health law was being overused to make up for this issue. There was also no ability to make end-of-life care decisions for someone who was never able to make those decisions for themselves. So they were sort of stuck in a legal limbo. And when they established the major medical decision-making process, they set up under Mental Hygiene Law Article 80, specific medical, surgical, dental, or diagnostic interventions or procedures that are covered. So these are what can come to SDMC for a decision. And that's any procedure that involves general anesthesia, significant invasion of bodily integrity, a procedure with significant risk, chemotherapy. Hospice is also included under SDMC, and then any other treatment or procedure for which informed consent is required by law. So that means not just anything that might involve informed consent, but something that is specifically under law has to rise to a higher level and have a higher level decision made. And there are certain things that are excluded that SDMC cannot make decisions about. And the first one of those is routine diagnostics. So blood draws, physicals, treatment, if it's just a treatment for the flu without any extraordinary measures involved, regular medication administration. Dental care performed under a local anesthetic is not an SDMC major medical procedure. Emergency medical treatment is covered under a different part of public health law that allows for physicians to make that call. We are not allowed to make decisions about electroconvulsive treatment or sterilization and termination of pregnancy. And additionally, SDMC is not authorized to make decisions about withdrawal or discontinuation of life-sustaining treatment, except as provided in the Healthcare Decisions Act, which we will get into in a little bit. So this is what was authorized by the Healthcare Decisions Act. So this did not go into effect until 2009, I believe. There's obviously a big gap in time when both of these were established, which is part of why they're a bit different. But end-of-life care requests are authorized by the Surrogate Court Procedure Act, Procedure Law, Article 17A. And that authorizes SDMC to make decisions of withdrawal or withholding of life-sustaining treatment for persons with an intellectual or developmental disability. And what is meant by these end-of-life care requests is a do not resuscitate order or a do not intubate order, restrictions on artificial nutrition and hydration, the use of antibiotics, vasopressors, chemotherapy, blood transfusions, comfort care with hospice services, or any other treatment that is deemed life-sustaining. So that could be, stopping dialysis treatments because that is a life-sustaining treatment, but a physician might deem that it's, futile or there's side effects to it that are affecting some other part of it. All of these are really those end-of-life orders that kind of get decided when someone's close to death. And we'll look at the next slide here where we talk a bit about eligibility. This shows us the major medical care and end-of-life care difference between eligibility. And with end-of-life care, you can see here that in addition to the diagnosis of intellectual and developmental disability, there also needs to be an illness or injury from which there is no recovery and which will reasonably cause death within 1 year, permanent unconsciousness, or ongoing medical condition with a requirement of life-sustaining care that will cause an extraordinary burden. For major medical care, for people who need to come and get a decision made, the qualifier is that they have to currently receive services or formerly have received services at a program licensed, funded, or operated by the Office for People with Developmental Disabilities, the Office of Mental Health, or the Office of Addiction Services and Supports. So for end-of-life care, we just need a diagnosis of intellectual or developmental disability plus that illness that requires life-sustaining treatment. Major medical is based on providers. And then we also need, the person also must lack capacity and not have a surrogate to make decisions for them. So if you think you're working with someone who does need to get a decision made by SDMC, how do we go about that? We're going to take a look at our application process here. First of all, we need to figure out who's going to be our declarant. So the declarant you'll see on our paperwork is the term used under the law for who is submitting a declaration of a need for a surrogate decision making. The declarant's the person who submits that declaration. They're someone involved with the care. They really can be anyone involved with the care. It could be the health services provider, maybe the director of the individual's residential facility, the nurse at the facility. It could be a relative who is unable to make the decision and wants to issue this. It's just someone who's familiar with the person who needs the decision made and can really speak to their abilities, to the family status, to those medical needs that are being requested. We just really need this person to be the chief contact for the whole request. They provide the official submission with the declaration, and then they're actually going to sort of troubleshoot and answer questions and make sure that everybody else who's involved in this request gets us what we need so we can make that decision. So where do you find the forms? You find them on the Justice Center website. The website is justicecenter.ny.gov/SDMC. to get our forms. If you go to just the Justice Center's website, you see that advocacy and support link at the top. You'll click on that and scroll down a little bit. You'll see SDMC on there. Or you can just go to Google and Google SDMC forms, and you should be able to find us here. And so when you get to this page, you'll scroll down a little bit and you'll see apply for a major medical care decision or apply for an end of life decision on the left-hand side. And you'll find all of our forms there. So if you're applying for a decision for major medical treatment, there's 4 forms that are needed to submit a complete packet and get things moving along. This really happens after the treatment team has been discussing what's going on with the person, what treatment has been recommended by the doctor, what are all those care options, what's the best option to move forward here. That happens before you get to SDMC. SDMC isn't to choose between different types of treatments. We're really here to say doctor has said that this is what is needed. We need to decide if that's what's best for them. So the declaration form is sort of what I was talking about earlier, where the declarant is going to write down all the contacts, the care coordinator, all of the people who are involved in that person's care, who need to be notified of this hearing. And they also will touch upon things like, is there a surrogate? Is there any family member who might be involved in the person's life who could possibly make this decision for them? And how did the person react when someone explained this procedure to them? The first form is Form 200, but it's the last form that needs to be signed because the declarant needs to say that they've read the certification on capacity and the certification of medical need as well. And our capacity certification is done ideally for each of these requests. We want to make sure that the doctor who fills that out, and it's a New York State licensed psychologist or psychiatrist who has to do this, that they talk to the person about that procedure. So if the question before the panel is going to be a colonoscopy, we ideally want that capacity evaluation to have been a discussion about a colonoscopy so that we can know, what it is that the person understands or doesn't understand about that. The third form that we need is a certification of medical need, and that's completed by the physician, dentist, or podiatrist who is ordering this major medical treatment. They're going to need to outline exactly what they'll need written on the consent. So what is that procedure called? What is it that they need to do? Are there any biopsies involved? Are you going to use anesthesia? What are the risks and benefits? Are there any alternative treatments? That's all of the information that's going into those forms. And the declarant is going to gather this from the psychologist or psychiatrist and from the physician, dentist, or podiatrist. The biggest thing to remember when you're doing that is just to make sure they've actually filled it all out. So we want to make sure that there's no blanks on the page, that they really did write in there what it is that they're requesting and why, because that's very important for when the decision's being made. And also that they're signed by the correct person. Unfortunately, we can't accept physicians' assistants or nurse practitioners' signatures. It has to be co-signed at least by one of these physicians. So for capacity, New York State licensed psychologist or psychiatrist. For certification on medical need, a physician, dentist, or podiatrist, depending on what the treatment is that's being requested. And our final form, again, can be filled out by the declarant. It could be filled out by the nurse. It's someone with knowledge of the individual's medical history and needs can put together, what medications is the person taking? Are there any different medical conditions they might have or other testing that's been done that might be, affected by this procedure? They're going to gather all that together on our paperwork and make sure that it's all filled in, and then also provide some supplemental information, details on the last physical, any consultations that are required related to this procedure, lab work. We ask that you just submit all of that to us together in one packet so that we can have all of our answers right in front of us at that time. And the way that our questions are phrased on these documents mirrors what the Mental Hygiene Law Article 80 requires of us. So when you're filling these out, you're actually meeting all the needs and getting all the information that's required under the New York State law about this. Next, we have our end-of-life care. These are also available on our website, as I said before. And it's different because this is based on a different law. So this is Surrogate Court Procedure Law, Article 17A. And the 300 form is basically like the 200 form. We have a declarant who completes that. They're putting in all of the information about contacts that are service providers or any other contacts that the patient might have. And excuse me, I will use patient intermittently because we have it written on our medical forms for the doctors to fill out. So it's really a proposed patient. We have to gather all of that onto the 300 form. And then once again, that's the last item to sign, because the declarant is going to also need to gather a certification on capacity for end-of-life care. This process is a little bit different from the major medical care in that for end-of-life care, we need to have that form filled out by the attending physician, and then also have a consulting physician or a New York State licensed psychologist who also provides a certification on capacity. And one of those people must be certified by the Office for People with Developmental Disabilities as having worked with people with developmental disabilities, having knowledge of that population. The 320AB is our attending and concurring certification for end-of-life care. Once again, a little different from major medical. We need 2 physicians who sign off on whatever the medical care is that's needed in this end-of-life care request. Our form offers a lot of options and really walks through what needs to be filled out so that we can hit the requirements of, explaining exactly what the extraordinary burden of this care would be if it was provided, all of those details that are specified in the law. And then we also have our related medical information for end-of-life care, SDMC Form 330, very similar to the major medical request as well, where we're just looking for that medical history for any other indications that might affect any part of this care that's being requested. And we do also, again, request any supplemental information, consults, hospital records, anything that's coming up right now, labs that would be relevant to this. And one of the big things with end-of-life care is that it's really important that the person who requires care has had a conversation about the care. That's on our 300 form, and it's also part of the certification on capacity. It's very important that someone has actually taken the time to explain what it is that's being requested, what it would mean to have CPR, why do you want to have a DNR in place, just to really get their feedback and see, what it is that they do understand about that and how they feel about it. So once we get the declaration actually completed, it gets submitted to SDMC. You can submit it by mail, but we discourage that. We prefer to receive it by fax or email because it's a lot faster and easier to track. So you send us your declaration, all 4 forms, and any supplemental information. We receive it, put it into our system, and then an SDMC nurse will review it and do the case processing. So a nurse will contact the declarant and ask questions about what has been received, point out any areas where maybe something got missed or we just need further information, make sure that all of the details in the forms have been filled out and meet the requirements of the law that authorizes it, and make sure that we have all the details there. She'll also walk the declarant through what the process is, just sort of talk a little bit about hearings and anything in the paperwork that might need, additional information and support. So say the nurse that she was speaking to, nurses the declarant, and they don't really know that they can speak to exactly what this procedure is. The SDMC nurse might say to them, is it possible to get someone from the doctor's office to also attend the hearing who can better explain what this procedure is? So they're there to help. They're there to walk you through the process and help answer any questions that there might be. And then once we get that case processed and make sure all of the paperwork is in, SDMC sends it to our regional contract offices. So there's 7 regional offices across the state. A hearing is held by someone who's actually in that area of the state with volunteers who are there too. Pre-pandemic, everything was in person. We met at a location that was convenient to all involved. So usually at the person's house or at day program, someplace that made them comfortable to go. Since the pandemic, we've been doing everything virtually. So it's very similar to this Zoom hearing. We have a meeting over WebEx, except that we could see each other. All the people involved are on there together having a conversation, including the person who needs medical treatment. So they hold a hearing. Everybody comes together on a WebEx and has the discussion. Most times that decision is issued at the hearing. The panel comes to a decision, they issue it, and if it's granted, they give the consent to the participants right there. And we move on from there, and they can actually schedule the procedure. If the consent is not granted, the denial is issued right there. We are able, if the consent was denied and something changed after the fact, some significant medical thing had changed, there's new information, we can reopen the decision in those situations. There are two other options. If the panel does not reach a decision, they just have no decision, we do schedule that for a second hearing and get it back there. That's pretty rare. The panel is also able to say, we don't have enough information before us to make this decision, and we need to follow up with another proceeding to make that decision. So that's also an option too, where we would schedule a second, we call them a conference call, schedule another meeting to do that. They can also find that the person has capacity or has a surrogate and move on from there. So we're going to just pop up another poll for you, just to kind of talk a little bit about what we've been talking about. And there you go. It's just a poll about major medical procedures, just to hopefully reiterate what we've been saying. So which of the following of these are major medical procedures that do require informed consent? And you can check all that are correct. Okay, let's see some of those poll results. Looks like a lot of you are getting this. Yep, it's dental exam and fillings under general anesthesia, and chemotherapy would count as major medical. The other two, dental exam and fillings, presumably with a local anesthetic, and blood work are not. So we're going to move on now and talk a little bit about hearings and what's going on in an SDMC hearing. We want to make sure that providers who are present.
Nikki?
Yep.
I'm sorry, there were 6 questions during that session.
Okay.
Yeah. First question is, would the agency director be considered a conflict of interest to be the declarant?
No. Really, there are not conflicts of interest for declarants because we want somebody who definitely knows that person and can speak to them. So yeah, it's a representative. You're advocating for the person who needs the care. It really can be anything. We can't tell you exactly who it can be, unfortunately, because you're better equipped to choose, but it can be anyone.
Okay. How long does it take the committee to make a decision after receiving paperwork?
So if the paperwork was all perfectly filled out and all the questions were answered, we can really get that to a hearing fairly quickly. There's an option for doctors to specify that something needs to be expedited. And what that does is, under the law, it changes the rules around notifications. So we can, if a doctor says something is expedited, we can get that scheduled for a hearing just as quickly as possible. If something's not expedited, we are required to give 5 days notice of when the hearing will be scheduled or when the hearing will take place. So if it came in and it was perfect and the contractor found a hearing date that was good, it typically would be at least 5 days out, unless we got waivers for that. Our goal is within 2 weeks. For just a non-expedited case, within 1 week if it is expedited, but in actuality, it's much quicker than that, what we're actually turning around.
Thank you. How far in advance can you submit a declaration or a request, especially for end of life?
End of life is pretty difficult because you do have to meet those qualifications. So we can't really in advance say there can't be too many advance directives because of the way the law is written. You have to meet the threshold to be eligible in the first place. If somebody has a specific question around that, I would really encourage you to call us because we'd be happy to talk it through with you and get you in touch with mental hygiene legal service as well to try to flesh that out for when it is the best time to make that decision.
Thank you. And can a doctor submit their own consent if they have one?
We don't sign other people's consents. We issue a consent that's legally authorized for any kind of consent. So they will receive a document from SDMC that says this is a consent for this procedure, and then it has legalese about other related procedures and all of that information. We're not going to sign the doctor's form, but we are certainly used to answering that question to doctors' offices. So if you have an SDMC consent and you have a medical provider who's just, not sure what it is and they don't know what to do, have them call us, because we're happy to talk to them and explain that it is legally authorized and they don't need something else.
Thank you. And one person said they have a parent who doesn't attend meetings and won't sign consents for any procedure that a specialist requests. Do you have any suggestions for handling that?
I think so. Typically, when it's something specific, we would say, give us a call and we'll try to help you figure it out. In general, if there is a parent and that person wants to make medical decisions, they are the ones who get to make it. And SDMC can't overrule another decision from a different surrogate. So we would only be able to act in certain cases. However, and I'm going to talk a little bit about surrogates in a minute, but the person needs to be legally authorized and also available and willing. So if there was a surrogate, so let's say there's a parent, you can't get a hold of them, you've left numerous messages, sent them, certified letters, all of this documentation is out there. SDMC might be able to help if somebody's actually just not available and not answering that question.
Thank you. And for end of life hearings, will they ever go back to being in person?
I don't know. We have not made a final decision. I can say for all of our hearings, we always have the option of maybe, if there's something going on and we can get some people to meet in person. I should note with end of life, so for major medical, the individual who needs the decision made is required to attend, unless there's some really, there's strong guidelines around when they might not be able to attend. For end of life, they can be visited by a panel member just to kind of get that one-on-one interaction, because sometimes people are unable to actually speak, so we need to sort of visually see them. We can always do that with, whether it's virtual or non-virtual. We have a lot of options available to us. So I don't know, whatever our decision would be on virtual or not virtual would probably apply to both major medical and end of life. But we're doing our best and trying to make sure that we keep everybody safe and that we're not, inadvertently creating any kind of COVID situation.
Right. Does the SDMC committee make end of life decisions for CAB persons?
We do not.
Okay.
There is a surrogate list that is going to pop up just shortly. That'll show Consumer Advisory Board for Willowbrook comes ahead of SDMC in the OPWDD hierarchy. So they go to the CAB decision makers, not to SDMC.
Can a family care provider make decisions on end of life care, or do they need to go through SDMC?
If the person somebody needs to be an authorized decision maker. So if the person has an intellectual disability or a developmental disability and has no surrogate or legally authorized surrogate, so if the family care provider was a guardian or healthcare proxy, they might be able to make decisions. And OPWDD would probably be the best place to get a specific answer on that question.
Okay, just two more questions and then I'll let you go on. What's the relationship between SDMC and mental hygiene legal services, and can MHLS object to the proceedings of a hearing?
Yes.
Okay.
Yeah, MHLS is the legal representative of the person who needs the decision made. So they're essentially like counsel for the patient in the situation. They have legal rights, including objection rights. For end of life care, if there's an objection by MHLS, is just one of several individuals who can make objections. If there is an objection to an end of life hearing, the SDMC process stops and that needs to go to court for a decision. Major medical, if there's an objection, the panel can think it through and bring that into their decision-making process. After the hearing, the lawyers can take this elsewhere as well, so that MHLS and OPWDD or OMH, all of these providers can take this to court afterwards and not implement the SDMC decision.
Can a stepbrother or stepsister serve as a surrogate?
They are, so step siblings are not in the hierarchies, so they would not be seen as an authorized decision maker unless they were a healthcare proxy or a guardian.
And in the chat, someone has noted that for OMH, the family care provider cannot be the proxy or decision maker, and OMH cannot act as a guardian in those instances. So
thank you. That's helpful. Yeah.
Okay, I'm out now.
Okay. Thank you, Davin. Thank you, everybody, for your questions. Those are really good questions. I'm going to move through this a little bit quickly so that we can, get to Stephanie's portion and have enough time to discuss all of those pieces. But at an SDMC hearing, I want to make sure that everybody who's participating in a hearing potentially in the future knows what's going to happen. So at a hearing, the panel is looking at 3 really important questions in this order. They're looking at capacity. They're asking, does this individual have the capacity to understand the risks, benefits, and alternatives to this medical procedure? And then they're looking at a legally authorized surrogate. So is there a legally authorized, willing, and available surrogate who can make this decision? And number 3, is this procedure in the best interests of this individual? They're going through these in order because if they decide that the person has capacity, we're not going to look at the other things. It doesn't matter. So they have capacity, the hearing ends, the panel says, we think you can make this decision on your own. That's the decision that's issued. Same for a surrogate. If they decide that the patient does not have capacity, but that there is a surrogate available and willing who can make this decision, once again, the hearing ends. Nobody looks at best interest because that's the surrogate's job to do that. So they have to decide no capacity and then no surrogate in order to get to best interests. And so what we're looking at when an SDMC panel is making a decision is informed consent. And we want to make sure that the individual has had the opportunity to show whether or not they can provide informed consent. So they've had a full explanation of the proposed procedure. They heard the risks and benefits. They were given information about the level of discomfort and effect on functioning, disclosure of alternative procedures, and they know that they can give consent or not give consent and change their mind at any time, because those are the rules around informed consent. And when we're evaluating capacity, so our panel members are taking a look at they're having a conversation with the person, they're asking questions, and they are getting information about whether the procedure has been explained. So that could be in the capacity evaluation, and then it should also be supplemented by some testimony that says, yes, I talked to him about this. We've, explained that the dentist wants to pull these teeth that are infected. And then they're going to ask questions to see if there's comprehension of that. We want to make sure that we're actually paying attention to whether or not they've demonstrated the understanding as opposed to just repeated some of the information. But this is what we're trying to get at. Is there capacity there because the person has the knowledge and now has comprehended that? And then we're also going to look a little bit at whether it's voluntary. We want to make sure, by that I mean that the reason for the decision isn't because someone said to do it, the doctor said I need to have this. Like, we want to make sure that it's not the outside influence, that it really is based on that person's feelings. So when the panel makes this decision, if they think the person lacks the ability to consent or refuse major medical treatment, that means that they could not understand the proposed medical treatment, that they did not understand the risks, benefits, and alternatives, and that they were not able to make an informed decision about it. The standard that they're going to use to make that decision is clear and convincing. And that means that they've received evidence that's highly reliable and upon which the reasonable persons may rely with confidence on the probability of its correctness. So we want to, actually, it's a pretty high standard, clear and convincing evidence for both capacity and surrogacy. We want to make sure that the quality of the evidence provided really showed that in all probability, this is the accurate decision to be made. What this means basically is like if the evidence at the hearing about capacity really just didn't hit this threshold, then the default should be that that person has capacity to make their own decision. And same with surrogates. If we couldn't prove that there was no surrogate, then we accept that there is a surrogate. And legally authorized surrogates under SDMC authorizing law, MHL Article 80, are a parent, a spouse, an adult child, or a court of competent jurisdiction. And there's no hierarchy here. We can't really say it should be the adult child, not the parent. That would be decided by someone else. But if there's any of these people involved in that person's life, then SDMC can't make the decision. And if it's a person who's served by OPWDD, OPWDD actually has a hierarchy in their regulations that outlines who can and can't make decisions. So if someone's served by OPWDD, SDMC is at the end of this list. If there's a guardian or a healthcare proxy, they get to make the decision. A spouse, a parent, actively involved adult child, and then there also are these actively involved adult sibling and actively involved adult family member. And that definition is a family member by blood. So that, as someone asked earlier about step brother and sister, it unfortunately doesn't meet the qualifier for the actively involved family member. So they would actually have to get the law to recognize them as a surrogate if they wanted to make decisions. But, you know, a cousin who's been really close with this person their whole life meets with them every Saturday and they talk about medical care and all of these things. That would be an actively involved family member under OPWDD regulations. That person can make the decision. There we go.
I have a quick question.
Sure.
What type of questions are used to determine capacity?
They usually start off with simple questions like asking, hi, how are you? You know, getting to see if the person's able to speak with them, if they're saying relevant things to the topic. We also go off of what that capacity evaluation might say. So that should be, you know, from a clinical setting where there was a discussion about this procedure done. Really getting into like risks and benefits, I think it's really important to kind of know, like, do you understand that there are some risks to having this procedure done? And if the person can clearly articulate those, that's what's going into it.
Thank you. And just one other question. What about a brother or a sister if the person was adopted?
So illegally adopted, I think so, but we're getting into the nitty gritty. Yeah. We would probably need to pull in MHLS or another attorney to really look at it. Yeah. But I do think so. If you're adopted into a family, then those people are also in your family. And I should also note, with siblings, I think it's also by marriage. So it could be your sister-in-law, but it's that and same with like a stepmother could probably make decisions if the parents were married. But sometimes we run into issues where they weren't married, but that person is involved and doesn't quite count. If you're running into any of those situations and you want to run a question by us, we have attorneys here at the Justice Center who help us with this. So we could present them with the situation and help you figure out who the best decision maker is.
And you can also help figure out, you know, what is there a certain standard for a family member who's actively involved for determining that? We can.
There is, yes, yep. There is a specific guideline for that, and so that is good to know as well.
And the committee does acknowledge people who are nonverbal, you know, as much as possible. So
absolutely, yep, yeah. We will communicate with people any way they need. If they need interpreters, we have interpreters there. If they, you know, they're with their staff. If we know for a fact that they don't communicate well with other people, with new people, we will ask the staff member to just kind of talk to them and try to get, you know, however it is that they like, if it's sign language or if they have a book that they use as a communication device. Yeah, we're willing to try anything. And it's never assumed that someone does not have capacity. I think that's the most important thing with this program is that we're always looking, do they have the capacity to make this decision? And only this one decision. We're not saying, you know, you can't make another decision tomorrow. If there was another procedure that came up, they would come back to SDMC. One more note is we have on our paperwork a description of a correspondent. So a correspondent is not a surrogate, but is someone who's involved in that person's life, has a genuine interest in promoting their best interests, has a personal relationship and participates with that person in their care. It could be some kind of advocate, a friend in the community. The family care provider actually on our paperwork is put in this section as a correspondent. It's someone who's involved in the person's care, and is, part of their life, but isn't up to that level of surrogate, can't make the decision for them, but does have a role here. And they are, under the law, required to be notified of hearings and included in the process. But anyone, I will also say, anyone can be invited. If there's some member of the community who doesn't really rise to that level of correspondent, or isn't a surrogate and doesn't fill into these roles, and the provider knows about them, have them come to the hearing. If they're able to speak to this, they should please attend. Our final question that we're looking at is best interests. So we want to make sure that we're always promoting the personal well-being by the assessment of risks, benefits, and alternatives of a proposed major medical treatment by taking into account relief of suffering, preservation or restoration of functioning, improved quality of life, the individual's quality of life with and without treatment, their personal beliefs and values that they might have. We want to make sure that we're really getting any information that person can give us. If we've decided that they don't have the capacity to make their own decision, we're still going to consider their opinions and thoughts on this. We're still going to look at, like, how do we make that decision? Well, we're going to look at whether it's going to relieve suffering or improve their functioning. And we want to base it on that person's quality of life, not on my opinion of what a quality of life might be. And for best interest, the legal standard is different than it is for capacity and for surrogacy. For best interest, we're looking at a fair preponderance of the evidence. And that is evidence that, when weighed on its quality rather than quantity, tips the scale to give consent or withhold consent. So we're really looking for like 51% of our opinion is to make the decision one way or the other, because we're really looking at a little bit more of a vague, you're always looking at risks and benefits and whether this is in their best interest and how it will help them in their life. It's not always a concrete, quantity of pieces of evidence that you can weigh. It's the quality of that information. It's knowing, well, if they have this surgery, it will make them, have less pain, and they'll be able to ambulate a little bit more, and where they can eat more freely, and eating is one of their favorite things to do. So that quality standard is a little bit different. And now we are at our break. Davin, has anything else popped up before we take a break?
Just one question, maybe if you could just clarify again about the role that a correspondent can play.
Sure. So a correspondent is, these two are in the law, and they're sometimes very confusing. A surrogate is legally authorized to make the decision, and so they're identified as a decision maker. A correspondent is like more involved than an acquaintance. So it's somebody who's actually involved in this person's life. The family care provider is a good example. They're not authorized to make decisions, but they know this person really well, and they talk to them about decisions that have to be made, and they work together on, going to appointments and doing all sorts of things. They really know what's going on with them, and they're an important part of that person's life. So they're legally authorized to attend the hearing. We need to make sure that they're there. I hope that answered it.
Welcome back from the break, everybody. I hope you enjoyed getting to see some of those adorable dogs on the screen. So I just wanted to know, I know that we're getting a lot of questions specifically about surrogacy, and it can be a complicated process. So I think what we're going to mention here is, if you have a specific question about surrogacy and if somebody qualifies, just give us a call or send us an email. At the end of the presentation, our information will be shown on the screen too. We would be happy to talk to you about specifics and provide some, advice on if they could be a surrogate, or refer you to the appropriate contact. So for the purposes of the presentation, just so we can get through some of the content, we are going to hold questions until the end. And if we're not able to get to your questions too, we can follow up after. But for some of those very specific ones, please just give us a call. So in this section, we're going to talk more about the hearing process and the roles and responsibilities of our volunteers. Again, as Vicki noted, by taking this course, if you are interested in becoming a volunteer, this will serve as your introductory training. There are some steps you'll have to take after just to complete some of the documentation and review some other guidance documents, but this will serve as the initial training, which is exciting. So let's talk more about preparing for an SDMC hearing, because it's always important that people are prepared so we can support a smooth process. So before the hearing, our contractors will reach out to the providers, reach out to volunteers in the area to secure a date and secure volunteers. Once the contractor has selected a group of volunteers and set a date with the providers, they send out a notice of hearing. The notice will include the date, time, and location of the hearing. Right now, we are holding our hearings remotely through WebEx Cisco. With that comes some complications too, so we always tell people to please test your WebEx connection prior to the hearing. Our contractors do a great job to set you up for success. They send out guidance documents for it. They give you a test WebEx link. So always please just make sure before the hearing your video is working and your audio, because we do have a requirement for our hearings to have the patient by video, and also all of our volunteers need to be by video. So prior to the hearing, all of our volunteers and the participants will receive a copy of the case packet. So that will be either the 200 series major medical packet or the 300 series end of life case packet. Sometimes we do have combination requests where maybe there will be part of a major medical and end of life request, so you could receive that also. In the packet, it will tell you, what the medical request is. It will give you a copy of the capacity evaluation and then any supporting medical documentations that you need to see. We always want to note that outside research should not be performed before the hearing. Please leave your questions for the hearing so that all participants can be involved, and so that everybody could do a web search and you get kind of differing information, just so that the same information is being discussed at the hearing. Also, please, as a volunteer, don't contact the doctor before. Any information that you're looking to gather should be at the hearing and also needs to get on the record. We also have several resources on our website for volunteers. So if you go to our volunteer webpage, you could even Google SDMC volunteers. You'll find a volunteer handbook and guidance documents. I think our guidance documents can be really helpful because we have separate ones that go over, the major medical process and what we're looking at, specifically guided towards, what are the best interest factors that we're, discussing here when making decisions. And then we also have some other materials that kind of give you some frameworks of what are some questions that you could ask for capacity. I know that was kind of one of the questions that was asked. So, what's some guidance in terms of things that you should look for when you're asking capacity questions? Same thing, surrogacy and best interest. While those questions are really helpful, we always try to remind people that you want to guide your questions toward the specific request and also make it individualized in terms of what is the individual capable of answering. So kind of use your assessment there too, and kind of how you phrase questions, use simple language for people. We all know when sometimes you go to the doctor's office and things are really complicated, it can be hard to understand it. So use that judgment when you're talking to the individual and even providers themselves too. On the provider end, it's equally important that you are prepared for the hearing. You want to make sure that you understand what's being requested, that you are prepared to explain the medical procedure that's being requested or the end of life care plan. For our end of life hearings, we recommend that a doctor, the attending physician usually be present just to explain, kind of what the person's medical condition is, what's being requested and what those extraordinary burdens are. So just making sure that you have all staff present that can explain the medical request, explain the risk and benefits of, continuing or, having this medical procedure, and if there are any alternatives. Again, for providers, we also have guidance materials. Many times when the nurses are going through the case processing, they'll ask providers, is this your first time submitting a case? How familiar are you with the SDMC process? And they will also send you guidance materials to review and help prepare you for the hearing. So let's just talk a little bit more about the hearing. I always like to note that it's important that everybody be on time. If people are late, it can push other hearings that we have scheduled in the day or even cause a delay for that hearing if we have to cancel it. So to support a timely decision-making process for the individual, please be on time. That happens all around. That's for our providers and our volunteers. There is a requirement for us to have at least 3 volunteers to hold an SDMC hearing. We always try to fill our panels with 4 people, so we have a 4 panel member committee, but if there's an emergency and someone's not able to make it, we can proceed with 3 people, but it makes the voting more complicated, so we always at least try to have 4. SDMC hearings are similar to a court proceeding with evidence and testimony gathered throughout the hearing to support the medical necessity of the treatment being requested and the person's lack of capacity to make their own decision. Hearsay is allowed. So if a provider was at the doctor's office and the doctor explained this is why the treatment is needed and they are conveying that to the panel, that is considered qualifying information to put on the record and to consider. For our process, we provide an adequate notice of hearing. So Vicki touched on this a little bit in terms of some of our legal requirements. So for non-expedited cases that are not as urgent, we have an obligation to provide a 5-day notice of hearing to all interested parties. Interested parties for SDMC process is the declarant, the director, mental hygiene legal service, the patient, and then any surrogates or correspondents that are involved in the process. So that's who we would need to legally provide that 5-day notice of hearing to. If we need to hold the hearing sooner because something changes, or maybe there was some scheduling conflicts, we can get waivers from those interested parties, just saying that they waived their right to a 5-day notice of hearing. That 5-day notice is not required for an expedited case where the doctor has said the medical need is urgent and we need to hold this as soon as possible. The other thing that we like to note, because there's a lot of legal aspects to our process, is SDMC provides legal assistance and support throughout the process. So while we do have mental hygiene legal service there, who is the person's legal advocate, SDMC is the program that should be providing advice on our process. But mental hygiene legal services input is definitely valuable because a lot of times they can help to also clarify some of maybe surrogacy questions that come up throughout the process. So we all work together, but SDMC will provide, the final determination when it comes to our procedures and process. On the screen here, you will see the hearing participants that are involved in our process. So we have the declarant, that's the person who completed the case submission and who is familiar with the individual. We have the nurse usually. We definitely need someone medical from the team that can talk about the best interests of the procedures, and any other providers that have insight and information about this individual's capacity level. If there's anybody else that can make a decision and talk about the things that we're going to be talking about at the hearing. The individual needs to be present at the hearing unless there's a medical reason why they couldn't be, but this has been less problematic since we've been holding our proceedings virtually. We also have the 4 panel members, and we're going to talk about the roles of those panel members in the next slide: mental hygiene legal service, the local SDMC representative, and any correspondents and surrogates that are involved in the person's life. So when the SDMC program was being developed, the legislators wanted panel members to have certain expertise and sensitivity to the care and treatment of individuals with special needs. They decided that panel members should be from one of the 4 following positions. They should be a New York State licensed medical professional. This can be someone who is a nurse, a doctor, or even someone with a social work background. Anybody who has a license to practice some type of healthcare in New York State. A New York State licensed attorney, because they bring with them experience when it comes to decision making and the ethics and law within New York State. An advocate who has experience working with individuals with special needs, or a family member of individuals with disabilities, or individuals formerly served by one of the agencies that we serve, because of course they bring valuable knowledge to the process too. For our process, we create a record in various ways. The hearing is recorded. Any information that is discussed other than deliberation is placed on the record. Providers who are testifying are sworn in just to confirm that they affirm to tell the truth throughout the process. Their name and position is put on the record. Our panel chairperson helps with the hearing process. So the panel chairperson is one of the panel members from those 4 positions. They help to open and close the hearing. So we have a script that helps to keep them on track. They help to keep our panel focused on the 3 issues that are being discussed and in order. So we go through capacity, surrogacy, and then best interest. And then they help to guide the deliberation process, which is actually not recorded, and help the panel to come to an agreement in terms of their votes throughout the process, which everybody is making their own votes, but they also talk as a group to kind of think about what do they think about the treatment and if anybody has any information that they would like to provide during the voting process. It is important as a chairperson, that you are also receptive to SDMC's support throughout the process. So specifically the contractor, because the contractor is the one that is responsible for making sure that SDMC policies and procedures, are followed appropriately. So we'll talk a little bit more about the major medical hearing. So I had mentioned all of our hearings are scheduled by the contractor. There is a requirement, under law that the patient be attending. We have testimony from the care providers, explaining what the medical care is that is being requested, why they feel like the individual is not able to make their own decision. MHLS will be there, and then it's facilitated by the SDMC representative. We'll get a little bit more into what the consent consists of for major medical care. So consent can be requested from 60 up to 365 days. So for example, 365 days, a lot of our dental requests fall under 365 days because there can be scheduling issues in terms of getting somebody in for an appointment or follow-up care might be needed. The consent, once it's issued and approved by the SDMC panel, is not specific to a particular healthcare provider. The consent is specific for the individual. So it's for them if there's another doctor that needs to do the treatment, once they're scheduled for it, as long as they're certified to, they have permission to under the SDMC consent. Vicki talked about this too. Also, additional consents are not required for our SDMC process. So if the doctor says that they have a specific form that they want us to sign, that is not something that we typically do. The other thing is anesthesia is not specific. So if the doctor described that they would be using IV sedation on their paperwork, but they decided that a higher level of anesthesia was needed after preoperative screening, they have the discretion to determine what type of anesthesia is appropriate at that time. Also, our process allows for related procedures to be performed under the consent. So if a colonoscopy is approved, but it didn't include, the removal of a polyp, once they did the colonoscopy, the physician would be able to move forward with removing that polyp, because of course we wouldn't want the individual to have to go under another colonoscopy to remove that, since it's related and necessary. But again, with a lot of our processes, if you have questions about, what our consent covers, definitely give us a call. We'll help you walk through that process. Those are some typical questions that we get along the way. The SDMC end of life hearing is pretty similar to a major medical, with the exception that when we're in person, the individual is usually hospitalized. So sometimes they might not be a part of the hearing if we're doing an in-person proceeding. What happens then is a panel member would visit the individual before the hearing and have a conversation with them to assess capacity and their medical condition. And the contractor would help to pick what panel member could actually go and meet with them in person. For these circumstances, the panel member would then come back to the other panel members and participants during the hearing and just, communicate what was discussed, any observations they might have had about the individual, if maybe they're nonverbal. And then the conversation on capacity would continue. Then they would be looking to talk to the providers during the hearing in terms of, has the individual ever expressed any moral and religious beliefs? Because again, this is a very sensitive decision that you're making, right? Talking about somebody's end of life care. So we want to know, did they ever have any preferences in terms of what they would want or not want at the end stages of their life? And it's really important to look to the providers for testimony, because they can really help to help you understand kind of what was this person's decision-making ability before, what were some of their preferences, what are things they enjoyed in life, and why would it be helpful or not helpful to continue down this road for them. Vicki also kind of touched on this when she was talking about end of life eligibility for individuals with an intellectual or developmental disability. The attending and concurring physician must certify that the individual meets one of these medical criteria to submit a request for end of life care. So the person needs to have a terminal condition where there's really no hope of recovery for the person, and they're expected to pass away within the next year or so, that the person has an unconsciousness, or that they have a life-sustaining treatment that is irreversible and will continue on indefinitely, and it's not helpful to continue life-sustaining treatment. So this is all part of the process, as panel members, that you're talking about at the hearing, right? What is the end of life request? What is being requested, and what is the medical condition? The doctors must also certify that there's an extraordinary burden of continuing life-sustaining treatment within the request. So they're explaining that outside of this individual's diagnosis, that there is a degree of pain that they're feeling. What is the degree of pain with or without treatment? They're helping to explain, how the treatment that is continuing is futile, it's not helping them, and also looking at their quality of life factors here, right? So what are the risks with continuing the treatment, and how is it only kind of prolonging their life and not helping them to get to a previous level of functioning that they were at before? When there is a request to withhold artificial nutrition or hydration, there needs to be a separate discussion by the panel on this, okay? So the panel needs to ask the doctor for testimony on, why are you looking to withhold or withdraw artificial nutrition and hydration? And this is important, right? Because food and water are considered a basic human right. So if we're looking to withhold or withdraw them, we really want to know that there's no hope of recovery for this person, or it's really providing an extraordinary burden. And those are the two things that you'll be discussing with the physicians. Is there no hope of maintaining life for this person, or is the artificially nutrition causing an extraordinary burden for them? And I will say, from my experience of observing a lot of hearings, the doctors do a really good job of outlining this, really explaining kind of what their level of functioning was before they came into the hospital, many times when they're at the hospital, and kind of where they are now, to kind of show that kind of decline in their health. So I think that can help the panel in making their decisions to know, is this really helpful for them? Is there really no hope? Because these are really difficult decisions, and I know that you want to be making a decision that's, you think is the best for the person. Comfort care can be included in the request if it's checked off on our forms. Comfort care is defined as medical care and treatment provided with the primary goal of relieving pain and other symptoms and relieving suffering. The important thing we like to note here is that if comfort care does not include other requests for life-sustaining treatment. So if withholding artificial nutrition and hydration was not included, that is not under comfort care. It has to be specifically stated on the consent. So comfort care does not, it doesn't kind of give that blanket for other things. It's merely comfort care. But again, things like this too, as a provider, if you had questions about what is comfort care, cover, give us a call and we'll help walk you through that. And we can also help you determine, do you need to come back to submit another request? Because, unfortunately, when it comes to end-of-life care, the person's care can change quickly, and additional life-sustaining treatment might need to be withheld or withdrawn. But when we did the original hearing, it wasn't necessary at that point. The SDMC decision for end-of-life care is issued in writing. SDMC is as identified as the decision maker. There is no expiration date as long as the person meets the 1750B criteria. It's the physician who determines if they continue to meet that medical criteria. We do ask that SDMC be notified if there is a change and the person no longer meets that criteria for end-of-life decision making, just so that we have, a heads up on that and we know that. I also like to mention, because these are sensitive issues, that if the panel does not provide consent, say they decide that they don't feel like the end-of-life care plan that's being proposed is in the person's best interest at this moment, if there's a change in the person's status, you can submit a new case packet for end-of-life request immediately, or alternatively, if maybe hospice is necessary or some other major medical treatment, you could also submit a request for major medical treatment. So there are options, even if the decision was not approved, if there's changes. So we do have a poll question right now, so I will ask for that poll to be opened. We're just looking here at your understanding of the end-of-life process and in terms of eligibility. So the question is, what individuals are eligible for SDMC end-of-life services? I've touched on this briefly, and Vicki touched on this in the beginning of the presentation. So I'll give you a minute to fill that in, and then we'll bring up the results. So it is a person who has an intellectual or developmental disability. I can see where the answer of any person who has received services through SDMC is a tricky one, right? So it's that intellectual or developmental diagnosis that qualifies them to receive services through SDMC. So like for major medical, we do serve individuals with a mental health disorder or a substance abuse disorder, but not for end of life. So. We also we touched on this too, kind of the objection process. Any interested party or MHLS has the right to object to the SDMC proceeding. The weight of the objection is different depending on the proceeding type. Any objection by a legally authorized surrogate or person receiving services in terms of SDMC making a decision will stop the hearing. An objection for a major medical hearing is noted on the record if it's made by any other party. So for example, if MHLS says they have concerns with the consent time and they're objecting to it for a major medical hearing, that would not stop the proceeding, but it should be noted on the record, and then the panel should take that into consideration when making their determination. And then any objection from an interested party or MHLS for an end-of-life proceeding would stop the SDMC proceeding. On the screen here, you'll just see some of the hearing issues that could come up. And again, I think our hearings can be quite complicated sometimes, so this will not cover everything. We have some of those procedures where, the risks are really high, so it's questionable on, are the benefits, are they going to outweigh the risk? Is this really going to be helpful? Is it going to help that person and improve their quality of life and get them, to a level of functioning that they were at before, and allow them to also engage in the things that they enjoy in their life? So we're looking at more of those complicated requests. Again, I think our panel members, they do such a great job when it comes to these complex ones. We've had hearings that have lasted an hour or so because it is so complicated, and people really want to make sure that they're having the conversations with the medical staff to really understand, well, why is this being requested then? And, can we see, is it going to be helpful, and should we move forward with this? I think some of those more complicated hearings are where we see more information request, because you might feel like you need some testimony from the doctors because you're really just not understanding, is there something else we can do here than what's being requested, because there are significant risks. Another, potential complication could be not having a clear answer on if the person can make their own decision. There are some folks that we serve that can be high functioning and, they can have, an understanding of it, but it's coming down to the conclusion of, do they understand the decision that they want to make? Do they have a rationale for making that decision? And do they understand kind of what the risks are of non-treatment and having the treatment? Those are some of the discussions. I think some of the recommendation when it comes to kind of capacity kind of concerns is making sure that you really try to have a thorough conversation with the person, use more open-ended questions rather than those closed-ended where you're just kind of getting a yes or no, so that you can get more insight to kind of their process and their comprehension of the procedure. And again, I think this is where some of our guidance materials could come in handy too. I think some of the other things that we see is treatment planning and testimony from panel members. Our panel members have a lot of background knowledge. A lot of our panel members are providers. So with them, they bring all of their expertise, and it can be hard not to try to answer questions or give your own opinion of things on the record. But it's important that panel members are only asking questions during the hearing, and that if they have information that they want to provide, that they kind of do that in deliberation with the panel and have those discussions. Another thing could be really difficult is an individual opposing the procedure. If it was someone from OMH, the hearing would stop. But if it's someone maybe with an intellectual or developmental disability, we would have to kind of do a little bit, more questioning to see, do they really understand why they're opposing it? Is this something that's typical for them? Do they usually reject treatment? You'd be looking to the providers for this. Another thing is weak testimony. Sometimes it can be difficult to support the request. So that's why we tell providers to really be prepared. But if there are providers at the hearing who really just are uncomfortable with the process, or who did not really kind of prepare well, that can be complicated for our panel members, because they do need a certain level of information to make a decision. We'll talk briefly about the deliberation and voting process. Again, I mentioned that the chair is the person who's going to be guiding this process. It's only the 4 panel members who are participating. It's off the record. If there were any objections by MHLS, this is when that should be considered. The panel is going to be voting on the 3 hearing considerations. However, if during the hearing you really do feel like the person has capacity, then the panel might be stopping earlier to stop and talk about capacity, because then they shouldn't be continuing on to vote on surrogacy or best interest if they're going to be granting capacity. Same thing happens for surrogacy. If you've gone through capacity, now you feel like there's a surrogate, you're going to want to stop at surrogacy, vote on those 2 things, and not move forward, because the panel would not be making the decision on best interest at that point if they've identified a legal surrogate. The thing to remember with surrogacy is you're looking at, is this person actively, are they available? Are they willing to make the decision? I think sometimes it can be difficult for our panel members to remember that the person for OPWD individuals needs to also be actively involved, and that's something the providers can help to answer. If there's additional questions about, the treatment, and you feel like it wasn't answered before going into deliberation, the panel can go back on the record and ask their questions. So we've talked about this too. The voting goes in the following order. Does the individual have capacity to make their own decision? We need 3 votes to determine that the person does not have capacity, 3 votes to determine that there's not a legal surrogate to make the decision for them, and then 3 votes to agree that the person should receive this treatment, that it's in their best interest. Other possible outcomes of the hearing is that the panel is not able to reach a decision. That would be a 2-2 vote to saying, no, this is not in their best interest, to saying that this is in their best interest. If a no decision is made, if a request can be reconsidered at a new hearing, so that's always an option. And then the other thing is that the panel might decide that they need more information to make a decision, and then that would result in a conference call. Other reasons why a conference call could happen is there is an extension of time needed on the consent. So say there was a colonoscopy approved, it was only approved for 90 days. The patient wasn't able to get in for the procedure within that 90 days. The provider can come back if the hearing was held within the past 11 months and ask for an extension. Same thing if a related procedure is needed. That's is not more invasive than what was originally requested. We can do a conference call for that too. So as a provider, if you have a question on if we can do a conference call, just give us a call, and the SDMC nurse who processed the case can help you figure that out. We're just going to briefly talk about some of the roles of a panel member as a public officer. So again, we've talked a lot about this too as we've moved throughout this. We expect our volunteers to be impartial decision makers, right? So you're making a decision that's in the best interest of the individual. That means also making independent decisions, you know, in terms of your own process of what you think is helpful for the individual. Also making sure that you don't have any biases coming into the process. If you know that you do not agree with colonoscopy procedures or a specific type of treatment, you know, that's something you're going to want to be aware of. And it's something that you could also make us aware of, so we know that you would not like to participate in hearings like those, because we want to make sure that we're addressing every case individually and that there's not any preconceived kind of opinions on treatment before going into that. The other thing is volunteers need to make sure that they do not have a conflict of interest with the agencies that we're serving or the individuals that we're serving, that you're being fair throughout the process, and that you're weighing decisions in the best interest of the person. We'll talk just briefly. I know we're very tight on time, but just try to bear with me. Give me a couple more minutes because I just wanted, these are kind of important slides, so I just want to make sure that we cover them. SDMC panel members are covered under entities under the Health Insurance Portability and Accountability Act, HIPAA. We have, you know, permission to disclose information because we're covered under entities for HIPAA information. So this means we're allowed to share the individual's information with you in a confidential manner. So for our process, typically we either mail or send things through secure email, the case information. Same thing with the providers. We have the expectation that as a panel member, you are also making sure to keep this information confidential. So, you know, before and after a hearing, you know, making sure other people don't have access to that information. Then after a hearing, just making sure that you're securely disposing of that information. So, you know, removing any files that you might have from your computer and then shredding paperwork that you might have that's printed out. Public officers may also not participate in a hearing in which they have a conflict of interest. So again, that would be financial interest that you have with an agency. If you know an individual at a residence, again, you have a responsibility to maintain confidentiality for the patient. It is expected that you wouldn't use your position to secure unwarranted privileges or exemptions. And it's important that you do not engage in ex parte communication. So that's any communication that would happen with another person about the process outside of the hearing. So just making sure everything is happening at the hearing on the record. And you'll learn more about this if you want to become a volunteer, because you'll have to read the public officer laws and regulations, and then you'll have to actually sign it too. So we have one more poll just to bring up briefly. This is just
I think we could probably just skip the poll.
Okay.
Because we're at 4 o'clock, but we actually are at the summary. Okay. If we skip the poll.
That poll was just about panel members' roles, and it's everything that we've already discussed. So, you know, and you'll learn more about that if you want to become a volunteer in the handbook. So just to wrap things up, if you would like to become a volunteer, there are a couple of steps that you'll have to complete after this. You'll need to visit our volunteer webpage. Information will be sent out after this session to kind of direct you there. There's a post-training packet that you'll need to complete that just gives us all of your information. And then there's also a public officer's oath that you'll have to sign and get notarized. I like to mention notarized because you have to go somewhere and get that done. If you have questions about becoming a volunteer, feel free to send us an email. If you have questions about the forms as a provider, give us a call and definitely take a look at our website for some of those resources. I just want to briefly kind of go over that we have some of these specific resources. We have a mock hearing video that goes over the hearing. So as a provider, if you're kind of uncomfortable with the process, want to see what it looks like, definitely take a look at that video to, see what that looks like. We have the volunteer handbook that provides some helpful information about, some issues that have come up and have memos and information, provides copies of the paperwork so you can see it. We have sample forms on our website for major medical case packets and end of life case packets. So if you're looking at what we're looking for in these forms, definitely take a look at it because it shows you a completed major medical and end of life form. And then the webinar training for the 200 series forms is really helpful because it walks you through step by step how to complete a major medical packet. So I know that was a lot of information to cover. So I think we can stay on to answer some questions if anybody has them. But again, always feel free to utilize our resource, which is on this screen, to reach out to us.
Right. And in the chat too, we've given contact information so people can follow up with you, because many of the questions that we've received are just very specific about, some case specific things. So I think that would probably be the best way for people to follow up with you on those questions. So
excellent.
Thank you, Stephanie and Vicki. This was really informative.
Thank you, everybody. We really appreciate it. And please let us know your questions and we'll help you sort out whether it comes to SDMC or not.
Yes, thank you so much.